Hello, my name is Nasser Ashgriz. I'm the professor at Department of Mechanical and Industrial Engineering here at University of Toronto. I'm also a lawyer specialized in patent law and intellectual property. I'm going to take a few minutes to tell you about a non-disclosure agreement. Many of you are going to get involved in projects which are assigned to us by a company, and they ask us to provide them with some agreement that we keep all the information they provide to us confidential. This is called a non-disclosure agreement. I want to give you some of the information that are in this non-disclosure agreement so that you know what you're signing. I'll start with the basics and we go further down to the every steps in the non-disclosure. The first part of any non-disclosure agreement tells who are the parties involved. So the first may say, this agreement is made between a recipient and the company. The recipient is the student, the supervisor, or any other person involved in the project. Some of the non-disclosure agreement may put in the chairman of the department or the dean of the department. Those are the ones which are a little bit overreaching, and we don't like that. However, if there is such non-disclosure agreement, it should be brought to the attention of the chairman and the dean to see whether that can be waived or they're willing to put their names in. But anyway, because non-disclosure agreement is a contract, the names of the people involved are very important. They have to be there. The second part of a non-disclosure agreement is the confidential information. What is the confidential information? Most of the NDAs, they say anything to do with the business of the company is confidential information. But that can be also be more exhaustive list of information. For instance, it can be designs, inventions, processes and methods, drawings, plans, techniques, formula, patterns, devices, products, computations, software codes, even things like financial information such as pricing and costing information, customer information. Any information that a company considers to be confidential should be marked as confidential, or it should be told to you that it is confidential. So you want more detailed information in terms of what is confidential information so that it doesn't cause a problem in the future. There are certain things which are not confidential, and you can always indicate that the information that was given to you, you knew it before, or the information was in public domain, or the information was obtained through your own research, or information was obtained through a third party which was not involved in this agreement. So if any of those information provided to you in such a way, they're not considered confidential. And in fact, this is the issue that brings these cases to courts. You may say, I had the information, the company says, no, I gave you the information. So those are always the legal litigation issues. So what happens to the data afterwards? Most of the NDAs require you to return all the information that you have obtained. So they may have statements indicating that recipient will return to the company retaining no copies, all documents relating to the company's business. So in order to make sure that you may not have any issues in the future, it's better that you completely return everything you have to the company as soon as the project is finished. The time span is another very important issue that is in all the confidential agreements. In many cases, the agreement may say, recipient agrees at no time during or after the term of the project disclose any such information. Well, this is a confidential information with no time limit, and usually it's not very good from your sake. You're a senior year student, you may want to find a job in a company which is a competitor of the project you're working on, and this may result in issues. Therefore, you may like to have more time limit on the confidential agreement that you're signing, such as confidential agreement may say, recipient will continue for the greater than of 3 years, or it may say until 10 years after. These are very long term, of course, and the shorter you make it, the better it is for you. What happens if the confidential agreement is breached? So if for some reason the information leaks out and the company finds out about it, there are certain remedies that they can do. First, they can sue you for the financial losses. If the company, for instance, finds out that this information was used by a competitor and for that reason they lost a certain amount of money, that money can be recovered from you. The other very important statement that you see in the NDAs is that there's a statement that goes like this. Violation of this agreement by the recipient will entitle the company to an injunction to prevent such competition or disclosure. Injunction means that the company can go to the court and get a court order preventing you from disclosing the information. This court order is before any lawsuit. So because the company may find out that it takes a long time for the lawsuit to complete, but during this time you're going out and still giving out information, they may go to the court immediately and get an injunction. Courts usually do not like to give this kind of injunction, but if you have signed such an agreement, then they will give it to the company. And most of the NDAs have this agreement. So you're signing that the company can go and obtain an injunction. Another important factor that is in the NDAs is the governing laws. Most of the time, companies choose a state or a province or a country that is to their benefit. In most of our cases is the laws of Ontario, because most of the companies we deal with are in Ontario and the benefit comes from here. But you may find other provinces and states that may be more towards the benefit of the company. Consideration is another part of any contract. A non-disclosure agreement is a contract. A contract between the two people usually is binding if there is consideration. Consideration means financial benefit. So either the non-disclosure agreement may say the information is provided for the consideration of $1, or they may have other considerations such as know-how, educational value. So it doesn't have to be financial or money-wise benefit. It can be other kind of benefit, and that makes the contract or this agreement binding. What can you do with the confidential information? Basically, the only thing you can do with the confidential information is to use it to do the project you're involved with. You cannot use it for any other purpose. If the confidential information has to be provided to other people, for instance, you have a technician that wants to make the device, you have to either get permission from the company or have the technician sign another non-disclosure agreement similar to what you signed. Most importantly, what you need to do is have certain procedure for keeping the information confidential. That way you can always tell the company that we have certain procedure written down, and everybody who gets involved will sign such information. The information are kept in such and such location and is not accessible to by others. Basically, the terms that I mentioned covers all the important aspects of any confidential information. Generally, an NDA gives the recipient a broad guideline of his limitation in sharing information, and it's rarely exhaustive in itself. NDA is primarily to the benefit of the company and outlines the obligation of the recipient. So please read these NDAs carefully, and if you have any questions, you can ask me directly. Thank you very much.